43. We've got some motions out, and
Bryson Miles Gurney, is that what you're saying?
Yes, Bryson Miles Gurney. We need to
Pardon?
continue this case, Judge. We've got a lot of motions out and some more being filed. I don't think there's any objection to the state.
Motions.
Motion to perpetuate the testimony of a witness in California. They objected the last time, so we've amended it.
Well, when do you want to go to?
What?
When do you want to go to?
Why don't we put it on, if you can, to the February docket, and we can get a lot of these depositions done.
How about that?
That's fine, Your Honor.
Okay, February 26th.
Thanks, Judge.
How about that?
That's
Okay.
the only other case I got, Judge, is Timothy Thacker, 22-456C.
Timothy Thacker, 22 CF 456.
Yes, Your Honor.
Okay.
Motion for bond. Our hearing's set for December the 7th on the violation of probation.
Yeah.
He's been in jail since September the 19th. He needs to return to his job, go to work, and then we'll have the hearing on the December the 7th. But there's no prejudice to anyone, him not having a bond. He needs to work. We need to get paid. He works for Mr. Ansley.
What's the bond right now?
He has no bond. It's a violation of
bond?
probation.
Your Honor, this is a, I'm sorry, I don't want to cut you off.
No, that's all right.
Okay. Your Honor, this is a violation of probation, therefore he has no right to a bond. Our concern, Your Honor, is the nature of the violations are he failed to keep his GPS charged, so we cannot assure the safety of the community and that he maintains and complies with the rules of the court and probation because he's already shown that a GPS monitor is not the answer. He has, at least on 4 occasions, failed to charge it and resulted in him being away and untrackable for at least an hour on those
4
times.
occasions?
Yes, sir.
We've got a problem on him, Judge, about the monitor itself. We've got some witnesses that testify to that, but we would install the monitor prior to it released. If it has a problem with it, then we'll turn himself in. But we had a real mechanical problem with that before, and we're going to be able to show that, I think, at the hearing on December 7th. I just want to get
Well,
it.
you can show me something at December 7th hearing maybe, but at this point, I'm going to leave it the way it is.
Okay.
Thank you, Your Honor.
Thanks, Judge. We'll go to the 7th. Okay. That's all I got, Judge. Thanks.
All right,
Okay.
thank you.
Okay. If I don't see you anymore, happy Thanksgiving, Judge.
Same to you. Morning.
Randy Ulrich standing in for Jennifer Flowers, Your Honor. I've got 2 cases on the docket. One is Shane Collier, 22 CF 663, 22 CF 665, 22 CF 2690.
Morning, go ahead. What we got?
Your Honor, I believe all 3 cases are violations of probation. I'd like to enter a denial in all 3.
Okay. Setting for, what's our date that we talked about for VOPs?
Yes, new law violations, Your Honor. Maybe they can all track with the new law.
What about February 26th, pretrial?
Your Honor, Ms. Flowers mentioned a miscellaneous date of December 7th. I'm not sure.
All right, December
Then
7th.
it's fine.
Okay, thank you. December 7th.
Next, Your Honor, I have Allison Snipes in 23 CF 1824, which is also a violation of probation.
Okay.
And Judge will enter a denial for her as well and ask for the same date.
No
December
objection.
7th. Thank you, Ms. Ballantyne. December 7th. Thank you.
And I believe that's all I have, Your Honor, if I may be excused.
Thank you.
Thank you.
Judge, I've got some out of custody that I can call.
Okay.
Darius Livingston, Judge, this is going to be a plea to PTI.
All right, let me find him.
Since he won't be sentenced today, I don't know that the court will need a full plea.
Not usually, no, as long as that's acceptable with the court. And I can put the exposure on the record if the court does wish it.
All right, Darius Livingston, 23 CF 1306. You're Mr. Livingston?
Yes, sir.
Would you please raise your right hand to be sworn? You swear the testimony you give before this court's the truth, so help you God?
Yes, sir.
You want to enter a no contest plea to charge of child abuse without harm and enter a PTI program, and if you complete it, charges will be dismissed, but if you don't complete it, then you could be subject to be sentenced, I guess, it's a plea to the bench kind of a thing.
It would be at that point, Judge.
Okay, do you understand that, Mr. Livingston?
Yes, sir.
Did you read and sign this plea and sentencing agreement?
Yes, sir.
Are you aware of the rights you're waiving by entering this plea? Has anyone forced you or threatened you to enter this plea? Are you under the influence of any medication or drugs that would prevent you from knowing what you're doing here today?
No, sir.
And this is a third-degree felony. You would be subject to 5 years in prison if you were found, if you fail this PTI. You understand that?
Yes, sir.
Not saying you'll get that, but that's the maximum sentence you could get. Are you happy with the work Mr. Williams has done for you on your case?
Yes, sir.
All right. The court finds the plea is freely and voluntarily entered. The court accepts it. We'll defer any type of sentencing to give him a chance to complete the PTI program. And I don't see a date. Is it 12 months?
Yes, sir, it's 12 months.
12 months to complete the PTI program.
Yes, sir.
And, Your Honor, at probation's request, the cost of supervision would be waived. We have initialed that as well.
All right.
Thank you.
Thank you. Thank you, sir. Now get this done, okay? So you get the charge dropped, okay?
Okay. Yeah, you can. They're going to give you some very basic next instructions.
Okay.
Judge, I've got cook to lie on this. It's case number 23 CF 290. The case was set on the trial docket. We're here today. The state asked that it be set for call today. They wanted to have a chance to see if they would be able to get a hold of their victims and would actually be ready for trial.
Mark Cook to Lyons.
Yes, Your Honor. I was able to actually get in contact with the victim. The business is not a closed business. They are available for trial. And I want to say I just disclosed, and I believe I shared yesterday or the day before, additional witnesses for the state. They were revealed to me when I spoke with the manager victim of the case. She informed me that there were those two other people who were able to identify the defendant and got in communication with her, so I shared them with the defense.
They may have been sent over, Judge. I obviously haven't looked to see what they would say, or are there any written reports?
No written reports.
Statements that they made?
They did make statements about identifying the defendant, but they're not recorded.
Okay, all right. Give me just one moment. Judge, I was at the jail pretty much all day yesterday, so I've not really looked at this. At this point, Judge, I will move to continue the case so that I can review this information, maybe set their depots, something along those lines.
I cannot object because of the disclosure of the other
February
witnesses.
26th.
All right, Judge, thank you very much.
Take depositions and see what's up. If you can get it resolved.
Okay, I'll talk to them maybe take their depots, whatever I need to do, and let you know what they have to say, okay? February 26th. Okay.
Thank you. So that, okay.
Guys, that's all the out of custody that I have on this morning's docket.
Ms. Rivers then?
Your Honor, I don't have any that are out of custody.
Okay.
I know what Mr. Johnson's waiting for.
That takes care of our, don't we have another November 20th trial potentially?
Yes, there was the one with Mr. Gibbs, with Miss Ballantyne. He continued a few minutes from earlier.
I continued that one?
No, his client wasn't present.
Oh, I got you. Okay.
Yeah, she's in the red, Your Honor.
All right. So we could have a trial for Miss Ballantyne.
I need to address the court about that
All right.
when Mr. Gibbs comes, I guess.
Okay.
I've got, Purdue.
Good morning, Your Honor. This is Ladarius Purdue. He's before the court on 22 CF 2008. Your Honor, he was committed to the court for some competency restoration training with the Agency for Persons with Disabilities at Lakeview. When we were in court last time on September 7th, Mr. Sanchez had indicated he was still incompetent to proceed. The court gave a new date of today to get a status as to whether he is competent to proceed. I've not heard anything from Mr. Sanchez. I do not know why he's not present. I know last time he said he had filed a report, and I hadn't gotten the report. Do y'all have a report?
I have something from September 1st, letter.
Yeah, but that was, yeah.
Well, why don't we continue this because I don't remember seeing any report. We'll continue it to,
November 30th, Your Honor?
yeah, November 30th.
And I
Okay.
will call him and see
All
what
right.
the
Yeah, I haven't
issue
seen a
is.
report either.
All right. Right, but they said he wasn't, they said he wasn't competent on that one.
Okay.
November 30th.
30th.
Your Honor, the state did change one thing in the plea agreement, and I need to show that to Mr. Phelan.
Okay.
So, we've reached an agreement in this matter, if I may approach, Your Honor.
All right, this is 2019 CF 2175, 2019 CF 2215, 22 CF 2949, State versus James Francis Phelan. You're Mr. Phelan?
Yes, sir.
Would you please raise your right hand to be sworn? You swear the testimony you give for us court's the truth, so help you God.
Yes, sir.
Okay, you want to plea no contest
On the new law and the admissions on the violations of probation, Your Honor.
Okay. So on 22 CF 2949, you want to enter a no contest plea to unlawful use two-way communication device, third-degree felony, to facilitate a felony. Count 2, written threats to kill or do bodily injury, a second-degree felony. Count 3, unlawful use of a two-way communication device to facilitate a felony, a third-degree felony, and written threats to kill or do bodily injury, a second-degree felony. That's in 22 CF 2949. And then in 19 CF 2175 and 19 CF 215, you want to enter a admission to violation of probation. Correct, sir?
Yes, Your Honor.
Did you read and sign this plea and sentencing agreement form?
Yes, Your Honor.
Are you aware of the rights you're waiving by entering this admission and this no contest plea?
Yes, Your Honor.
Did anyone force you or threaten you to enter this plea
No, Your Honor.
and admission? Are you aware of all the rights you're waiving by entering this admission and no contest plea?
Yes, Your Honor.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Ms. Rivers has done for you on your case?
Yes, Your Honor.
Court finds admission and no contest plea freely and voluntarily entered. Court accepts it. In 19 CF 2215, you're judged guilty, 720 days Okaloosa County Jail, credit for all time served. Revoke probation, impose a new term of 5 years probation concurrent to all other counts. No contact or attempt contact with Winn-Dixie or any Winn-Dixie representative. Do not return to any Winn-Dixie. And same terms and conditions as 22 CF 2949 and 19 CF 2175. $100 cost of prosecution, $150 PD fee, waive cost of supervision. In 19 CF 2175, judged guilty, sentenced to 726 days Okaloosa County Jail with credit for all time served. Revoke probation, impose a new term of 5 years probation concurrent to all other cases and counts. No contact or attempt to contact with Target. Do not return to Target stores. Same terms and conditions as 22 CF 2949 and 19 CF 2215. $100 cost of prosecution, $100 PD fee, waive cost of supervision. In 22 CF 2949, counts 1 through 4, judged guilty, sentenced to 354 days Okaloosa County Jail on count 1 and 2 with credit for all time served. And 353 days Okaloosa County Jail on counts 3 and 4 with credit for all time served. 5 years probation on counts 2 and 4 concurrent with all other counts and cases. 4 years probation on counts 1 and 3 concurrent with all other cases and counts. Have a mental health evaluation, treatment, take any prescribed medications. Have a substance abuse evaluation, complete any recommended treatment with random UAs. No contact or attempt to contact with Jimmy Petronas or Ron DeSantis or their offices or representatives. You shall make no threats to anybody. You shall not possess any firearms. You shall remain in Okaloosa County unless granted permission to travel by the probation officer. 415, court costs, $100 cost of prosecution, $100 PD fee, waive cost of supervision. And that's it, correct?
Yes, Your Honor.
Correct, Your Honor.
Okay, thank you.
With tomorrow being a holiday, when do I have to, Monday for probation?
Your Honor, we will talk to him and let you know when to report.
Okay, thank you. Thank you, sir.
Unforced plea bargain downward departure, Judge.
Okay.
Your Honor, this is Destiny Sanders before the court on number 25. That would be 19 CF 2873, 20 CF 231. For violation of probation, we've reached an agreement in this matter, if I may approach.
Yes. You're Destiny Sanders? All right. This is 19 CF 2873, State of Florida versus Destiny Sanders. Would you please raise your right hand to be sworn? You swear the testimony you give for his course of truth, so help you God. Okay. You want to admit that you violated probation in 19 CF 2873 and 20 CF 231? Okay. Did you read and sign this plea and sentencing agreement form? You got to say out loud.
Yes, sir. I'm sorry.
Okay. Because it's recorded.
I'm sorry.
Okay. Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
Has anyone forced you or threatened you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today? Are you happy with the work Ms. Rivers has done for you on your case? Court finds the plea is freely and voluntarily entered. Court accepts it. Court's going to revoke and terminate probation on each case, sentence you to 90 days Okaloosa County Jail with credit for time served beginning October 20th, 2023, where you have waived prior credit before that date. $100 cost of prosecution on each case, $100 PD fee on each case, $50 PD application fee. So basically, do a little bit more jail time, no probation, and pay these things, okay? Then you're done.
Thank you.
Okay, stay out of trouble, okay?
And Monday's to collections, Your Honor?
Yes.
Thank you.
Your Honor, the next case that is listed is number 26, Nicholas Schaffner, 21 CF 166. Your Honor, when I went to go see Mr. Schaffner at the jail, he wasn't there. Research has found that there was an error in the e-filing process. I guess it went to the previous judge. And so I have resubmitted the order to transport and asking the court to set it for November 30th.
No objection.
November 30th, thank you.
Ready.
All right.
Your Honor.
Kenneth Stewart.
Yes, Your Honor, this is Kenneth Stewart on 23 CF 550. He has returned from Florida State Hospital. They have found him competent to proceed. I have met with him several times, spoken with him. I have no concerns, and at this point, I'd like to ask the court to find him competent to proceed.
State.
I don't object to the admission
I read
of
it.
the competency report, Your Honor.
Okay, admitted, find him competent to proceed, set him for February 26th. We'll move it up sooner if he gets it resolved.
And Your Honor, just to make the court aware, the victim in the case did file a request to drop the charges. The state has indicated they're going to reach out to him to try to see whether they're going to go forward.
Correct, Your Honor.
We'll move it up if
But
y'all-
if not, I mean, I may have to
Okay.
file a motion on that.
And I should know something by the end of the day.
Thank you, sir.
Today. We're done for right now? Uh-huh. Okay, Mr. Stamp. Your Honor, this is David Stamp. He was added to the docket. That's 22 CF 236, 22 CF 237. We've reached an agreement in this matter. This will be your copy, that way in case you need to give it to state.
All right, this is 22 CF 236, State of Florida versus David Charles Stamp Jr. Are you David Stamp?
Yes, sir.
Would you please raise your right hand and be sworn? You swear the testimony you give for his courts the truth, so help you God.
Yes, sir.
Okay. You want to admit that you violated probation?
Yes, sir.
Are you aware of the rights you're waiving by entering this admission?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Anyone force you or threaten you to enter this admission?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Ms. Rivers has done for you on your case?
Yes, sir.
Court finds the admission freely and voluntarily entered. Court accepts it. Court's going to adjudicate you guilty, if not already previously adjudicated. Modify and extend probation on both cases by 24 months. Complete all original terms and conditions. Complete Keaton bars to bed. Complete all required aftercare. Take any prescribed medication. If a violation occurs, then witness may appear via Zoom with a notary. $100 cost of prosecution times 2, $100 PD fee times 2, $50 PD application fee on 22 CF 236. Waive cost of supervision. Okay? Thank
Good
you.
luck. All right, you're going to have to talk to.
Your Honor, that's going to be 24 months from his original termination date of November the 16th, 2024.
Correct.
Yes,
Okay.
thank you.
So Mr. Gibbs is writing one up, if Mr. Williams is ready, I've got this one.
I am.
First would be Mr. Higgins. Higgins?
Judge, Mr. Hagan has a violation of probation on the docket for this morning. I'll be entering a denial as to that. He has a new law violation that is currently scheduled for arraignment on November 30th. My recollection, yes, is that state's filed an information on that. If the court's amenable to it, I'll go ahead and arraign him on that charge, enter a plea of not guilty on his behalf, 15 days for pre-arraignment motions, and demand trial by jury.
What's the new charge?
It is a carrying concealed weapon by a convicted felon and giving false name or ID to a law enforcement officer. That would be a first-degree misdemeanor. Count one would be a second-degree felony. I've explained to him at the jail.
I'm so sorry to interrupt, Mr. Williams. No, he's charged with carrying concealed weapon by convicted felon, count one. Count two is armed trespass of a dwelling, and the third count is loitering and prowling.
Let me show you the copy of the information I'm working on. And if you file another
Is it Mr.
one.
Hagan? Oh, Hagan. Almost similar charges. I'm sorry, Judge. I read another person's name.
I've got this as Kevin Allen Hagan, case number on the new law, 23 CF 2341. And then on the VOP, 21 CF 50. So he's got a second-degree felony, maximum 15 years on count one, and a first-degree misdemeanor, maximum 1 year on count two. And I went over all this with
All
him
right,
at the
so
jail.
he's pled not guilty.
Yes, sir.
And so February 26th.
Thank you, Judge.
Thank you.
All righty, sir.
Ms. Airbear.
Okay.
Angela Marie Airbear.
Yes.
Madam Prosecutor, would you consider deleting the battery on a law enforcement officer and allowing her to do PTI on the remaining charge or charges?
The PTI is extended for both cases. Is that what you're asking me?
She's asking that the battery on a law enforcement officer be null pros in exchange for her plea or her PTI on the others.
No, I'm not agreeable to that.
She's not.
Agreeable to that? You want me to have you call back this afternoon? You want me to leave the case on the trial docket? Or, well, not the trial docket, you set for the 26th, or do you want to take the PTI with the Batleo being on?
I would like to take the PTI, but you could clearly see in the footage that I didn't do anything.
All right, look, we can't have a conference here.
Yes, sir, Judge. At this point, it looks like we don't have
I would like
a
to.
plea on it.
I would
Set
like
it
to
for, looks like you might be kind of close, so we'll set it for November 30th.
Thank you,
I'll
Judge.
take it instead of going for the 30th.
All right.
I will only keep the PTI offer open for both cases until November 30th.
All right. Judge, she's just indicated to me that she has changed her mind. She wants to do the PTI rather than remain in jail until the 30th.
You got something drawn up for me?
Judge, I know that she's been trying to stay on top of her bills and that's been an issue for her. I did go out and see her again yesterday. We've had several meetings.
You know, what I said is, you got your paperwork drawn up for me.
Judge, I do. What I have, I don't think I have the referral sheet, but I drafted up the plea agreement with the conditions on it. And my understanding is that the state's going to send the referral over to probation later. All right, Ms. Hebert, you do not have to do this. You've got an absolute right to go to trial. You've got an absolute right to have me investigate the case further. I can set it for a bond hearing for you, but I don't think that I can do that legally today because there hasn't been any notice to the state.
Right, I'd rather just do it
All right, let me get your signature then.
Mr. Williams, I did get
There we go.
the PTI terms, the contract, so I can print it and bring it in a second, if you want to know.
Ma'am, do you mind if I date this for you?
No, go ahead.
We're printing the PTI terms out. Now it's the same thing that's on this document, and by the time you're done talking with probation, it should be in here, okay?
Your Honor, just so the court's aware, PTI will not begin until we get that agreement, the agreement. And when she signs the agreement after we instruct her, that's when we enter her here. That's when we enter her into the system.
It's being printed next door.
All right, Miss Angela Airbear. This is State of Florida versus Angela Airbear, case number 23 CF 1525. You want to enter a no contest plea in 23 CF 1525 and 23 CF 2280 to resisting arrest with violence, a third-degree felony, battery on law enforcement officer, third-degree felony, battery on law enforcement officer, third-degree felony, and trespass to structure after warning, a first-degree misdemeanor. So you're pleading no contest to 3 third-degree felonies and 1 misdemeanor to with sentencing to be this says plea to be held in abeyance. You mean
yes, sir. She enters the plea. If she doesn't successfully complete it, then the court goes ahead and she comes back, stands before the court for sentencing, but she doesn't actually get sentenced unless she violates PTI. If she doesn't violate it, the plea is then set aside and the dismissal entered.
All right. So you understand that, Ms. Hebert? Did you read and sign this plea and sentencing agreement form?
Yes.
You understand your rights that you're waiving by entering this plea?
I believe so.
Have a toss. Take her back until she has a chance to talk to Mr. Williams where she understands it or not.
Okay.
Thank you.
You have to
Oh, yes,
understand,
yes,
not
I do. I'm sorry. I
maybe
didn't know.
understand, not.
Yes, I do understand.
Do you understand or you don't, or you
Yes,
believe,
sir.
or you do understand your rights you're waiving?
Yes, sir.
Has anyone forced you or threatened you to enter this plea?
Yes, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today? Are you?
No, sir.
Are you happy with the work Mr. Williams has done for you on your case?
Yes, sir.
Okay, the court finds the plea is freely and voluntarily entered. Court accepts it, completes your PTI program, and then the charges will be dropped. Otherwise, you will be subject to being sentenced on these charges, okay?
Judge, I do want to clarify, because the state brought it up, the 8 hours community service work when she's not employed, that's 8 hours per week. That's if you're not working. Yeah.
Per week. Okay, that's what I wrote, per week, okay?
Thank you very much, Judge.
Thank you.
Okay, over here. Yeah. Now you go over here.
All right, it's 22 CF 3182, Guy Keith Jackson.
Judge, Mr. Jackson is currently before the court on a violation of probation, but he also has a new law violation that is set on the 11:30 docket. I believe the state's filed an information on that one. Madam Clerk, can you confirm the case number on that's going to be 23 CF 2337? Judge, in that case, I'd just soon go ahead and arraign him on that too, save him from being brought back
All
on the
right,
30th.
what's he charged with?
On that one, it's an attempted first-degree premeditated murder. I'll be entering a plea of not guilty on his behalf, 15 days for any pre-arraignment motions, and demand trial by jury.
And court appoints public defender.
We are already appointed. We were appointed
You
in
were?
first appearances
Okay,
on
sir.
it.
We'll set you for February 26th, okay?
Thank you very much, Judge.
Thank you.
More.
Judge, I had Mr. Moore placed on the docket. He filed a request for a Ferretti hearing. I currently have about 8 hours of deposition scheduled on 11/29. And if the court's going to find that he's competent to represent himself, then I want to be able to cancel those depots and put somebody else's depots
Let him
on
do the
that date.
depositions, and you can look at the deposition and decide if you want to represent yourself or not. Thank you. I mean, that's a lot of work right there, all those depositions, so we'll take a look at it. Thank you. I'll give you a hearing if you want it.
Okay, I do.
Okay, we'll see.
All right, Judge, I believe the next one's, I think that's it for me. Okay.
Mr.
Judge, my other out of custody is back present in the courtroom, Ms. Valentine.
Miss Valentine, okay. What do we do on Shailene Matthews with Mr. Nopes? I've forgotten.
Judge, I think we said it on December 7th.
December 7th?
Yes, sir. Just double check.
Okay.
Yes, sir, that was December 7th.
All right, so we got Ms. Valentine here.
Yes, Your Honor. Tim Gibbs on behalf of Miranda Ballantyne, Judge. This is 22 CF 1807. We had set this case for trial this cycle. However, the state informed me that the primary trooper is not available. Is that correct?
The primary trooper is not available the week of the 20th for family reasons.
So you want to continue it? Is that what you're saying?
I think that's what the state's requesting, Judge.
Have you had a continuance on it before?
We have, I think, for a similar reason.
You have?
The court continued it, I think,
All
at
right.
either one of our
February
requests.
26th. How about that?
Thank you, Charlie, that's fine.
Get it resolved if you can. I mean,
We have certainly been trying,
you can't
Judge.
keep having Ms. Valentine come back and forth, back and forth, back and forth. So get it resolved, or we'll get it to trial, one way or the other. Okay?
Thank you, Judge.
Okay, thank you. So that eliminates our November 20th trials, correct?
Yes, Judge.
I think so.
Okay.
Sure. Let's go. Your Honor, Tim Gibbs on behalf of Kayla Nicole Burgess. This is 23 CF 1138, violation of probation, Judge. We have reached an agreement, if I may approach.
All right. You're Kayla Nicole Burgess?
Sir.
Would you please raise your right hand to be sworn? You swear the testimony you give before this court is the truth, so help you God. You want to admit that you violated probation?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
You aware of the rights you're waiving by entering this admission? Anyone force you or threaten you to enter this admission?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Gibbs has done for you on your case? You are? Okay. Court finds the admission freely and voluntarily entered. Court accepts it, will revoke and terminate probation, adjudicated guilty, sentenced to 4 months, Okaloosa County Jail, credit for time served, $100 cost of prosecution, $150 PD fee, monetary requirements due within 180 days of release or to judgment.
Thank you, Judge.
How much time you got in jail?
I don't know if we really calculated it.
We calculated about 98 days.
98 days?
Yes.
Okay, well, you got,
That sounds correct, Judge.
you got just a few more maybe, okay?
Couple more days.
Should be just a few more, Judge.
Okay, thank you.
Your Honor, Tim Gibbs on behalf of Rocky Carter. This is 23 CF 80. I've met with Mr. Carter. We have been trying to resolve this if possible. The state's, again, last offer was that 30 months coterminous with his VOP sentences. I've been discussing with Mr. Carter what his options are as far as either accepting that offer, pleading to the court, or potentially setting the case for trial. I think we're coming to a situation where we're not quite sure what decision, or Mr. Carter's not sure what decision he wants to make. We had sent some counteroffers to the state. Those were respectfully rejected regarding potentially suspending any of the sentences. I'm still having some concerns for his competency, but again, as the court's aware, Dr. Zeman recommended that Mr. Carter be still found competent to proceed. We may be exploring that as well with a different expert now that his situation, his medical issues have also gotten a little worse. I think at this point, the only thing we can do is continue it and get it ready for trial.
February 26th.
May I speak?
No, February 26th.
I'd just like to speak if I may.
Well, I've already heard you speak many times, Mr. Carter, and you're always telling me you're a hunter. You're just a good old fella that hunts and fishes. And
I know,
you got heart problems, and you know, and you just you ever hurt anybody, and you know.
I haven't.
And I've heard it. I told you already. I was going to give you. I've given you 30 months. I'm going to give you no more than 30 months if you. But you don't want to do that. Yeah, no one's forcing you to do anything. So we'll bring you back on February 20. If we can get it resolved, we'll move you up sooner. Okay.
All I'm trying to do is keep me from having Mr. Zeman saw me, and he's. I know I'm okay, but he's worried about me having a stroke.
Okay.
Because of my epilepsy.
All
and
right.
I'm 65
well,
years
they have
old.
medical attention here in the jail, and if something happens, we'll get you. They'll take care of you. But I can't let you out on the possibility you may have a stroke. Everybody be telling me they may have a stroke. And
Well, all I was asking for was the.
Don't talk about the facts of your case. We're recording. Everything you say can be used against you.
All I
Don't
asked
talk
for.
about the facts of your case.
February 26th. Thank you.
See if we can get it resolved, okay? Did you get that printed yet?
Ms. Demby, no, I didn't give it to you. Your Honor, after Ms. Demby, can we bring back Mr. Johnson?
Let's do
He
that
had to-
now, so we can get those printed. Or do you already have?
No, I have this, and I give it to
Bring who?
Your Honor, Tim Gibbs on behalf of Tierra Demby. This is several case numbers. First is 19 CF 1483. 23 CF 27, 23 CF 277, 23 CF 606, 23 CF 828. I believe we have reached an agreement, Judge. I'm just going to briefly
Okay.
review that with Ms. Demby again so she can sign her written plea. Like I showed you earlier. Still what you want to do. I just need you to sign right there for me, please. And then today's date is. Your Honor, if I may approach.
All right. You are Tierra Demby?
Yes, sir.
Okay. Would you please raise your right hand to be sworn? You swear the testimony you give before this court's the truth, so help you God?
Yes, sir.
Okay, thank you.
Judge, no objection.
Now, you want to you want to admit that you violated probation in 19 CF 1483, and then plead no contest in 23 CF 27 to a battery on a detention staff, in 23 CF 277, count 1, 2, 3, all batteries on a detention staff, which is, all these are third-degree felonies. In 23 CF 606, battery on a detention staff, third-degree felony, and in 23 CF 828, battery on a detention staff or detainee.
So, Your Honor, the charges in those last three cases, she's charged with battery by a detainee. As part of the agreement,
Battery by detainee, okay.
Yes, Your Honor, and
yes.
those charges were all going to be reduced to misdemeanor battery.
Yes. So in 23 CF 277 and in 23 CF 606 and in 23 CF 828, all those charges are going to be reduced to misdemeanor battery, correct?
Correct, Judge.
Okay. So you understand that, Ms. Denby?
Yes, sir.
Okay. Did you read and sign this plea and sentencing agreement form?
Yes, sir.
You understand the rights you're waiving by entering this plea?
Yes, sir.
Anyone force you or threaten you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Gibbs has done for you on your case?
Yes, sir.
Court finds the plea and the admission is free and voluntarily entered. Court accepts it. In 19 CF 1483, court's going to revoke and terminate probation since you 21.3 months Department of Corrections credit for time served concurrent on all counts and cases. But I don't think I can do that if they're reduced to misdemeanor. So
You can do concurrent time, Judge. The misdemeanor sentences are going to be time served.
okay. All the misdemeanor sentences, that will be concurrent in all felony counts and time served in misdemeanor counts, correct?
Judge. We've seen it before where defendants have been sentenced to, say, 1129 in the jail, as well as a prison sentence on a felony charge. We say that they run concurrent so that they could potentially serve their incarceration in DOC to start their gain time.
I wrote concurrent on all felony counts and time served on all misdemeanor counts. How about that?
That works, Judge. Thank you.
100 and cases.
It's effectively the same thing.
$100 cost of prosecution, $150 PD fee to collections. In 23 CF 27, sentenced to 21.3 months Department of Corrections credit for time served, concurrent on all cases, $100 cost of prosecution, standard court costs, $100 PD fee to collections. In 23 CF 277, 23 CF 606, 23 CF 828, all are misdemeanor counts, sentenced to time served, concurrent on all cases, all counts, $50 cost of prosecution in each case, $50 PD fee in each case, all to collections, adjudicated, all counts, all cases.
Thank you, Judge.
Guilty. So I imagine, how much time have you served in jail?
Our estimate, Judge, put her at about 14 months.
14? You're probably going to go down to DOC for just a couple of months.
Yes, sir.
And then don't be hitting people,
Yes, sir.
okay?
Yes, sir.
She's in a much better treatment regimen now,
Yeah,
Judge.
don't hit people in the future, okay?
Yes, sir.
Okay. So
Okay.
you'll be out in a couple of months, and good luck to you, okay?
Thank you, sir.
Okay.
Okay. Thank you, sir.
Because we've got my case resolved.
Good, let's bring up resolved cases. Did you have more, Mr. Gibbs?
My next one's a plea as well, Judge.
Okay, let's do, Mr. We don't want to cut Mr. Gibbs short for just one.
Who do you have lined up, Deputy?
I've got the rest of yours, but I know we mentioned Johnson.
Yeah, Mr. Johnson, Your Honor, if I may recall the case,
Okay.
it's in the back.
Okay, Mr. Johnson.
I'll go sit over here.
He's been patiently sitting.
So high.
So have I.
So, Your Honor, Mr. Johnson has provided me with paperwork showing completion of the substance abuse treatment. So at
Okay.
this time, the state is requesting that the VOP be dismissed and probation terminated.
This is Brian Michael Johnson.
Yes, sir.
Do you have any objection to me dismissing the VOP and terminating your probation? You don't want to be on probation during the holidays? Okay. Probation terminated, dismiss VOP. Thank you.
Thank
Stay
you.
out of trouble. That's an order of the court. You got to stay out of trouble. Next. Mr. Gibbs, finish up.
Did you need Cody Farrell?
Pardon?
Ms. Farrell, let me grab the agreement.
Okay. Your Honor, we're back on the record. Now I have Mr. Cody Farrell, Judge Tim Gibbs on behalf of Cody Farrell, 23 CF 1084, 22 CF 2036. We do have an agreement. Ms. Leon is getting a written plea agreement as we speak.
Okay. Sir, what, back there, he's leaving. Okay.
Mr. Seals, he's here for plea day. He was told, I'm guessing by his bondsman, to be here at 9, because typically they do that.
Mr., is it Seals?
He's on the 130. I'm told.
Is he here for
Arraignment.
arraignment? Why don't we just do him, instead of, you want to come back later this afternoon, you want to do your arraignment now? Have a seat, we'll do it in a little bit, so you don't have to come back. Is that okay with you? Okay.
Mr. Gibbs, I'm still printing. It didn't go through the first time.
I'm sorry, Your Honor. I'm sorry, ma'am.
It didn't go through the printing, so I'm printing again.
We can announce it. It's fine with me.
Okay.
That's fine with me. Judge, the terms of the agreement that we reached in this case, so he's got a violation of probation as well as a new law violation. He was going to admit the violation and plead as charged. He would receive a downward departure for a legitimate uncoerced plea bargain for 11 months, 29 days in the jail with credit for time served, concurrent and coterminous between the cases and counts. Be assessed the court costs, and there is restitution. I believe we were just going to order restitution and figure out the amount within 90 days. There was some estimates of restitution in the discovery that we received, but we don't have any actual paperwork or formulations of how that number came about.
Well, so you want it, have you got your paperwork? You want it?
She's trying to print it now. I mean, I'm happy to.
I have the plea agreement. I don't have the restitution paperwork, though.
That's fine, yeah.
Okay, I
Yeah,
can grab
that's-
the agreement.
Okay.
Let's bring him back in a minute. You got another guy?
Yeah, we'll just bring it back in a second.
All right, thank you, sir.
Do you have another agreement that we can get through, Judge?
A.O. Gary?
Oh, he's not even. Your Honor, Tim Gibbs on behalf of Kyle Gary. Judge, this is 23 CF 2366 and 23 CF 2006. If I can have just one moment, Judge.
Okay.
Judge, he's on for a VOP arraignment this morning in 23 CF 2006. We'd like to enter denial for the record, and as well as on 23 CF 2366. I believe he's already set for arraignment either later this afternoon or on November 30th. We'd like to go ahead and enter a not guilty plea on that case. He's charged with failure to register as a sex offender.
All
We'd like
right.
to enter not guilty plea. If we could leave this set for December 27th, Judge.
All right, December 27th, pled not
Trial.
guilty, public defender appointed, and maybe we can get it worked out. Okay?
We'll try, Judge.
Thank you.
And we're back. We can have Mr. Farrell, please. Yeah. Judge, we're back on the record with Mr. Farrell's cases. Again, this is 22 CF 2036, 23 CF 1084. Just going to review the agreement with him again, Judge. That's what you want to do? Sign right there for me, please. Yeah, we won't be. And then today's date, please. Your Honor, if I may approach.
All right. Cody James Farrell, would you
Sir.
please raise your right hand to be sworn? You swear the testimony you give before this court's the truth, so help you God.
Sir.
All right, this is 22 CF 2036, 23 CF 1084. You want to admit that you violated probation in 22 CF 2036 and plead no contest to, is it 2 third-degree felonies, Mr. Gibbs?
Yes, Your Honor, there's an attempted burglary as well as the charge of cutting power to a building to facilitate a burglary.
All right, attempted burglary of an unoccupied structure and impairing power to facilitate a burglary, both of them third-degree felonies. You want to enter no contest to that and admit you violated probation?
Yes, sir.
Okay. Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Where the rights you're waiving by entering this admission and a plea? Where
Yes.
your rights you're waiving?
Yes, sir.
Anyone force you or threaten you to enter this plea and admission?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
The court finds the plea is freely and voluntarily entered, and admission is freely and voluntarily entered. Court accepts it. Adjudicates you guilty. In all cases, all counts, sentenced to 11 months, 29 days county jail, credit for time served, concurrent and coterminous. Revoke and terminate probation in 22 CF 2036. Total of $200 cost of prosecution, total $250 PD fee, standard court costs. Restitution to Tom Thumb Liquors, reduced to judgment, amount to be determined within 90 days. All other outstanding monetary requirements to collections. So, it's basically a jail sentence instead of any probation, correct?
Correct, Your Honor.
Yeah. If you want something to drink, go in and buy it. Don't be trying to break in, okay? Thank you.
Thank you, Your Honor.
Yes.
Thank you.
Thank you, sir.
Do I have a score sheet for this?
Forthcoming.
I can give you
We can provide that. I've seen it, and I don't have an objection to it, Judge. I believe that concludes my business for the morning, Judge.
All right. And we have is it Mr. Seals? All right, Mr. Seals, give me a case number and his name.
Your Honor, this is 23 CF 1814. Is it Kevion Seals? Kevion Seals, Your Honor. He's been charged by information with 1 count of possession of a controlled substance, as well as 1 count of possession of drug paraphernalia. He's not represented by an attorney, but I did just briefly speak with him, and I informed him that the plea, should he wish to enter a plea at arraignment today, would be to plea as charged to both counts. It would be an adjudication of guilt, and he would receive credit for all time served. There would be no jail, no probation, and there would be a $100 cost of prosecution and $515 in court costs. I also did give him notice that there could be a DMV issue with his driver's license, but he does have prior drug charges, and he said it's never been an issue in the past, but I did just put him on notice of that. He does have prior convictions. He does score 21 months, 21.6 months Department of Corrections, so I did inform him this would be an offer to resolve today, if you wish.
Credit for time served, sentenced to just no probation, just what he's already served in jail, credit for that, that's it.
Yes, sir.
Plus,
The court costs.
and is it Kayvon Seal?
Kivion.
Kevion? And what's the case number?
It's 23 CF 1814.
That was possession of controlled substance, and what else?
And drug paraphernalia is count 2, Your Honor.
Okay, so it was third-degree felony and a first-degree misdemeanor. You want to enter a no contest plea to those charges.
I don't know if he wants to plea or not. He does. Okay, he does want to accept, he's indicated.
Okay, you're charged with possession of a controlled substance, third-degree felony, and possession of paraphernalia, first-degree misdemeanor. The state's offered you, if you want to plead, you'll be adjudicated guilty on both, and I'll sentence you to credit for time served, meaning no more jail time and no probation. $100 cost of prosecution, $500 court costs. I'll give you 180 days to pay it or sent to judgment. Do you want to accept that?
Yes, sir.
Would you please raise your right hand to be sworn? You swear the testimony you give for this court's truth, so help you God. This is Kayvon Seals, 23 CF 1814. You want to enter a no contest plea to charge of possession of a controlled substance, a third-degree felony, possession of paraphernalia, first-degree misdemeanor, correct? Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
Has anyone forced you or threatened you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
You understand you'll be adjudicated and as a convicted felon, first-degree misdemeanor. You understand that?
Yes, sir.
And this could have some effect on your driver's license. You understand that?
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it. Will sentence you to concurrent sentence, credit for time served, $100 cost of prosecution, $515 court costs, 180 days to pay it, or before it goes to judgment.
May I approach with a score sheet, Your Honor?
Yeah.
And this is on course, downward departure.
All right, so it's a downward departure for you, okay?
Sir.
So just, just get that paid. You got 180 days to do it, or otherwise it'll go to a judgment, okay?
Sir.
Okay, thank you, sir.
Your Honor, if I can recall Mr. Roca for a moment, we have just a scheduling issue to discuss for next week. It appears as though the state's witness, the FDLE and lab analyst, is not going to be available until Thursday. Either way, even if we stipulate, it appears the state is going to want or desire that individual to testify and live testimony, so it appears as though beginning on Wednesday might be the best option. If we pick the jury Monday, begin Wednesday.
Why? Why not Tuesday? Don't we have any other witnesses besides that person?
Your Honor, the reason is because if my witness, the FDLE analyst, comes on Thursday and I close my case with that witness, then defense has to open his own case, and we're afraid that he may end up getting into Friday. So we just thought that if we start on Wednesday, we complete all testimony in both cases, defense and state, on Thursday, and then closing and deliberation on Friday.
Why don't we pick a jury on Monday and take testimony on Tuesday?
Because, again,
The state wouldn't be able to close their case in chief until Thursday morning at the earliest, Judge, which then puts us opening our case in chief lunchtime, 1 o'clock, Thursday afternoon. Then the potential of rebuttal and closings are then looming at that point. So, I mean,
we got a whole week set aside. I don't understand what,
yeah.
I mean, how many witnesses do you have?
6 witnesses, Your
6.
Honor.
Can't you take, we pick a jury Monday, and can't you take some witnesses all?
We could, Your Honor, but we will keep the jury the whole week here until Friday. So we thought we give a break on Tuesday, we start all the testimonies on Wednesday, and we go into Friday like that.
Mr. Stewart is saying they may not get finished. Is that what you're saying?
I just wanted to bring this to the court's attention. I know the state has some of the issues. It may be wise to start 9 a.m. Wednesday morning and work through it. Seek the court's guidance on it.
I believe Mr. Stewart was saying that we may not finish on Thursday.
Right.
If we start testimony on Tuesday. But if we start all testimony on Wednesday, then on Thursday, we close both cases, state and defense, and then Friday for deliberations and closing arguments.
This is something we can contemplate, we can handle Monday morning if you want some more guidance.
I don't understand why we can't take some testimony on Tuesday and some testimony on Wednesday, and then your FDLE guy on Thursday, and
Yes, and then he's going to have his case, and we may not finish Thursday evening. I mean, it's fine for the state. I can do it the whole week. It was for the jury
how
not to
long
keep
is your
it.
FDLE person going to be to testify?
It's not that long. I would say direct 30 minutes.
So that would be like, say, Thursday morning, right?
Yes, Judge.
And you cross-examine, you may ask 1 or 2 questions. And then you put on your side, how many witnesses you got?
I don't know at this point, Judge.
No?
Anticipate 2,
Okay, well, I'm not trying to rush you or anything, but, so.
one of which may be recalled from the state's case, Judge. I don't know, but
I mean, we could go into the next week because we just cleared up, those people pled. So we could go into a Monday if we had to. But I don't
Sounds
want to
terrible.
do that because then you got a weekend with a jury out there.
before holiday. Yes, sir. Okay.
One way or another, Judge, I don't believe we would go into the following week. Whether we start testimony on
All right,
Tuesday or
so
Wednesday, I don't believe we would.
Let's just, let's do our normal thing. Pick a jury on Monday, and we could even, maybe even do some opening argument Monday afternoon or something.
Yes, Judge.
I mean, So, I'm not trying to rush anybody, but we have a whole week, and I hate to just sort of, we're just going to not do anything for a whole day. Because sure in the world, we'll get to the point where, something's come up. Now we got to go into the next week. We could have done it. Was this the case that you were thinking about dropping one of the charges, or is that thinking of
It is.
a different case? Is that going to have any bearing if you decide to do that?
Not on the schedule of trial because I wouldn't be dropping the charge where I need the FDLE.
We're just going to go forward Monday, picking a jury, and we'll just go forward, and if we have some scheduling problems, we'll just do the best we can to work it out to be fair for everybody.
And when we're, during selection, Judge, I just want to be clear, we would be letting the panel know that it would be a week-long. We anticipate that service would be that entire week, so that there's no confusion, right?
Yeah, that's.
Yeah.
Okay.
So, okay, we'll get it worked out.
We'll get it. All right, thank you, Judge.
Okay, thank you. Yes, Ms. Turner, I forgot about y'all.
Yes,
Okay.
Judge, this matter is State versus Bill Ivan Myers. We have an agency number, we don't have a case number, it's just an investigation stage. But that agency number for the record is CPD 23 offense 2179. We've come to an agreement and we have a proposed order.
Okay.
Just so the record's clear, Judge, today the state did have a Christian police officer subpoenaed who didn't present, but there was a report that he had put together. I had not seen that report up until right after 9 o'clock or what have you. So once I saw the report, then I believe the state has met its burden.
All right, so you've read the report, and you have no objection to this entry of this order denying your objection. I mean,
Judge, I can withdraw my objection if that's the way you want to say it. But
okay, let me just sign this order to make it. We have it on the record. Okay, so okay, and that's right, Ms. Turner.
Yes,
that's
sir.
correct. Okay.
Yes, sir. Thank you very much. Thank you, Mr. Nope.
Yeah, what else do we have this morning? Is that it? We have, so all we have is the sentencing this afternoon,
We have
correct?
the Gabriel sentencing, and then there's a plea to the bench sentencing of two drug cases.
And I believe arraignments, is that correct? And arraignments.
And arraignments?
Yes, sir.
And then how many witnesses for our, oh, wait, we got where's Miss Flowers at? Is she gonna be here, right?
I'm assuming so. I haven't heard otherwise.
How many witnesses does the state have?
The victim might testify.
Might,
Might
okay.
not.